today I'm appearing as the junior counsel on behalf of the appellant in this case,
Yes.
whom I shall refer to as Mr. Smith.
Yes.
So, following on from the submissions presented to you by my learned friend, in order to support our main conclusion that the transcript should be disclosed to be used as evidence on behalf of our client, I shall be referring to the following two submissions.
Yes.
Firstly, that Article 8, the right to respect for private and family life, is not breached by the disclosure of this transcript. And secondly, that even if there hypothetically were to be a breach of Article 8, Article 6, the right to a fair trial, would still take priority.
Yes.
In addition, I shall be referring to the following legislation which you have in front of you,
Yes.
and the 2001 case of Reby to support my argument.
Yes.
So on to my first submission, that Article 8 is not breached by the disclosure of this transcript. I shall be submitting this first point, that the Article 8 rights of the children involved in this case are not sufficiently engaged due to the fact that the information concerning these children within the transcript does not amount to a gross invasion of anyone's innermost private life. Now it is stated on page 15, in paragraph 66.
Page 15.
So there's no to be
These two, yes, of course.
That the interest of anyone else...
And remind me, this is again...
Reby.
Which authority?
Oh, 2001.
This one is, what is the authority? Is it B?
Reby, yes.
Reby. Okay, thank you. Yes,
Okay,
on page 15.
So it is stated that the interest of anyone else who was involved
Yes.
and who could demonstrate that the Article 8 rights were sufficiently engaged
Yes.
could also have that effect that the litigant does not have the right to access to all the documents.
Yes.
Now, I wish to bring your attention here to the key word, which is sufficiently, the idea of being sufficiently engaged.
Yes.
My argument here is that contrasting with the facts of Reby, the facts of this case demonstrate that the Article 8 rights of these children are not sufficiently engaged, that the information concerning these children are brief facts on their ages, their schooling, for example, not intimate details like the ones presented in the Reby case, where the documents which were restricted consisted of a variety of intimate details, all which were all important and relevant to the case. For example, police interviews of the children, therapist notes related to sessions with the children,
Yes.
and also intimate details of the mother's private life. Now, within this case, the disclosure of these documents was regarded as, would have been regarded as
Yes.
amounting to a gross invasion of the mother's innermost private life, thus sufficiently engaging her Article 8 rights. So my argument is thus, due to the contrast between these two cases, the fact that these documents, this transcript consists of information that is basic factual information, not intimate details like those of the REB case, that therefore this is not a ground to order non-disclosure of the transcript.
Okay.